all of those. The relevance of that is that we went from just under a third of Oklahoma being a reservation to nearly half of the state of Oklahoma is now considered a reservation. Now, there's a lot of battles that are going on. There's a lot of fights happening in Congress. There's some threats of a congressional fix that would not be in the best interest of the tribes. The Attorney General is now trying to argue against everybody who claims that McGirt applies. But this has some very interesting ramifications. But it's not a bad thing. And I always have to remind people, especially state court judges, that there are still avenues for this case to be heard, whether it's in the tribal court of the Creek Nation, Cherokee Nation, Seminole Nation, Choctaw Nation, Chickasaw Nation, or it can be heard by the U.S. Attorney's Office in federal court. Now, at this point, the Attorney General's office is slow playing a lot of these cases. Excuse me. Tulsa County, for example, has over, I think, 200 McGirt hearings set for April. The court there is waiting for the Oklahoma Court of Criminal Appeals, the highest criminal court in Oklahoma, to issue some form of ruling on this to give them guidance. But right now, they are all moving into federal court or tribal court. What's interesting, though, and I think I'm probably preaching to the choir here, is that there's so much about Native American law, about Indian country, that we all know for a fact. We understand the law. It's very basic concepts of the law. What's shocking and disappointing is the pushback that I'm getting from state court judges, from state attorneys with the Attorney General's office or assistant DAs who don't understand some of the basic concepts of Native American law. In fact, within the first month, I think half the people who practice in Indian country in Oklahoma started to say, okay, this is evidence by itself why Indian law, Native American law, has to be a part of the bar exam, because they are basic concepts. And I'm speaking now as a practitioner, I'm getting statements from judges and from state prosecutors where they say, well, we don't think a McGirt applies to this individual because he's not Indian enough. And we have to point out, it's like, look, it's not the decision of the state. It's not the decision of the federal government. This is a decision of the tribe. And having to explain basic sovereignty to say, just because you think this person doesn't have enough Indian blood is irrelevant. The test is, are they Native American? And what's the test? If they are a member of a tribe, they have a certified degree of Indian blood, they have a card, they have a tribal membership card. Yet we're getting pushback saying, well, they're not Indian enough. And that's not what the law says. I have other judges who are saying, well, I've read McGirt, and McGirt dealt with what's called the Major Crimes Act. And under federal law, the Major Crimes Act involves only a certain limited number of crimes, mostly your more crimes of violence. And so state court judges in Oklahoma in these jurisdictions, some of them are taking the position that if it's not a major crime, then it doesn't apply. And trying to argue with the judge to say, Judge, it is a reservation is a reservation. It's not a reservation only for particular crimes. It is a reservation and the state has no jurisdiction. The Major Crime Act only defines as to who prosecutes, the tribal court or the federal courts. The state courts are out of this. And so a lot of these cases that are still being prosecuted, and in fact, Tulsa County, the Tulsa County District Court technically sits in the middle of a reservation now, but they are still operating, still doing business. And it's become this big debate as to how they do things. Now, there's all kinds of stories that are going on right now. And I mean, even I can talk about family members who, they get pulled over. Officer walks up to them and says, look, you need to slow down. Your tag's out of date. You can go on your way. Doesn't ask anything else because they have a tribal tag on the back of their car or they have their tribal ID with them. And the police officer for the city won't write them a ticket because they recognize, I don't have jurisdiction over you to even write a ticket now. So they're just pulling them over, slow it down, get your tag updated or whatever. And or someone gets in a car wreck where the highway patrol would normally write a ticket from the car wreck. They're not even writing the tickets anymore because of McGirt. That's not necessarily a good thing, but it is showing that there's an educational process that's going on. Um, as an attorney, I think I filed probably around 15, 16 McGirt cases in the state courts, asking to have old convictions thrown out. I've got one client who has 5 felonies from the early 1990s, and he would just like to have those off his record. He's living a productive life. He's got grandkids. He wants to go hunting again, and he's like, "Can you help me?" I filed a post conviction application asking to have all those stricken because jurisdiction is never waived. Subject matter jurisdiction is never waived, which obviously is also one of the arguments that we're having to have with the Attorney General's office. They are now arguing that we've waived jurisdiction, which I have to point out, it's like this is first year law school type of stuff that we talked about. Jurisdiction cannot be waived, and they're arguing.
Robert,
yes, sir.
for those who are not lawyers in the audience, can you explain to them what you mean by subject matter jurisdiction?
Yes, I apologize. I'd forgotten that my entire some of my audience are not attorneys yet, so I do apologize. And if I start to talk a little bit too much inside baseball, too far in the weeds, please forgive me. And Judge Thorne I wanted to reach out and slap me in the head by screen to slow me down. Subject matter jurisdiction. A court has to have the ability to have power over you. For example, if you're sitting in Sacramento, California right now, the municipal court in downtown Oklahoma City has no power or authority to order you to come to court for something if you've never appeared here. You didn't get a speeding ticket here, you didn't get a parking ticket here, you've never been here. They have no way to convict you, to charge you, to do anything because they have no jurisdiction over you. You have no contacts with this court. There's nothing being brought there. Obviously, you have to have something that brings you into the court. And jurisdiction is the beginning of any case because it tells you where you need to address a legal issue, whether it's criminal or civil. And they have to have both, personal jurisdiction over you, the person, and subject matter jurisdiction over the topic. And that's why we have these different courts. You have your separate state courts, you have your separate federal courts. Now, obviously, and I don't want to get too far off path here. If you're doing some work for a company in, let's say, in Arizona, and you go to visit them one time, you sign a contract there, and you go back home to Oregon, and you're living at home, and you breach that contract, then they might be able to bring you back into federal court, or if you agree to it in your contract, into a state court there in Arizona. I mean, obviously, they now have personal jurisdiction and subject matter jurisdiction over you. But for the tribal courts and for a state court doesn't have jurisdiction over a person if they are, number one, an Indian under federal law, and the crime that they have committed doesn't involve the state courts at all. I mean, just because they commit a crime, the state has to have jurisdiction. It would be no different than saying that the state of Colorado can prosecute somebody in Texas for something that happens in Texas. There's nothing happening in Colorado, and I'm speaking very generally on that. So for tribes, it's very unique in that they are in the state of Oklahoma, in the confines of the jurisdiction, but the state can't prosecute somebody on a reservation. You have separate sovereigns. The domestic dependent sovereigns that John Marshall talked about, a long time ago, is a separate sovereign from the state. And in the way I've explained it to people who don't practice Indian law, who are non-lawyers, I said, just imagine if the state of Texas all of a sudden was granted land right in the middle of Oklahoma, and they said Tulsa County now belongs to Texas. The state of Oklahoma has no jurisdiction within that county because it's Texas. We don't own it. We don't have any control over it. It's Texas land, and only Texas can prosecute it. That's the equivalent. But in this case, it's not a state that owns it. It's a tribe. Muskogee Creek Nation, and there are 11 counties, which encompasses one of the largest, that being Tulsa County, has that. They own it. But by law, they can only handle certain crimes and certain events. That leaves federal court. So the federal court in Tulsa, the Northern District of Oklahoma, they averaged anywhere between 10 to 14 indictments a month. That's the criminal charging method. They are averaging around 60 indictments a month for a U.S. Attorney's Office that's not that large. So the U.S. Attorney's Office, as a consequence, has had to ask for help. There are prosecutors from U.S. attorneys' offices flying from Fairbanks, Alaska, from Colorado, from Maine to Georgia, moving to Tulsa to temporarily help fill the gap on these McGirt cases. In these McGirt cases, they are not your typical federal cases. I spent 15 years as a federal prosecutor. I spent time as a military prosecutor, time as a state prosecutor. I've spent time as a state defense attorney, federal defense attorney, military defense attorney. And the cases you see in the state court, those are your, I'll say your grimy cases. Those are your assault with a deadly weapon. That's someone pulling a knife on somebody. It's a domestic violence by strangulation. It is your meat and potatoes of crimes that happen daily. At the U.S. Attorney's Office, their cases are typically more white collar, more multi-million dollar embezzlements. You know, they don't have a lot of violent crimes that go federal. So a lot of the prosecutors there are a little bit of a different gear. They're used to taking their time on a case. They don't have to indict or arrest anybody today. State court, they're arresting somebody today because a violent crime has happened. So you have a lot of attorneys in the federal system who are not used to these, I call them reactionary crimes. So they're being thrown out of their element a little bit, and they're having to bring in some state attorneys who are used to running and gunning and shooting from the hip. Problem is in federal court, you know, it's much more formal. The deadlines are much more tighter. There's a lot more filings, a lot more writing. So you've got this real interesting mixture that's happening right now. I've been appointed on 7 to 8 different McGirt cases out of the Northern District of Oklahoma, which is Tulsa County, and the Eastern District of Oklahoma, which is in Muskogee, Oklahoma. And these cases are run-of-the-mill assault with a deadly weapon, attempted murder, things that never fall within federal court or rarely ever do. And so I see a lot of these prosecutors who are used to a much slower pace scrambling. And as a defense attorney, it's kind of fun to watch some of these attorneys who've never really had to dip their toe into some of these crimes to have to scramble around and realize, hey, guess what? None of your witnesses are angels. None of your witnesses have much credibility. And I know you're used to us, you know, working out something to enter into a plea agreement, but I think my client wants to have his day in court. And so it's a lot of fun as a defense attorney. Now, McGirt has grown, and I meant to print this off and have it handy. There's a Fourth Circuit case up in Wisconsin, which is a public law 280 state. And I do want to say that some of the things I do talk about, I want to acknowledge that public law 280, Oklahoma is not a public law 280 state, and we don't have a lot of time, or we don't have the same type of agreements with the state. It's an all or nothing deal. Either the state has jurisdiction or they don't. I know with California, Wisconsin, and some of the other public law 280 states, it's a little bit different animal. But I know up at the Oneida Nation up in Wisconsin, there wasn't a McGirt issue coming out of whether or not a municipality had jurisdiction over a certain area of land. So McGirt kicked in up there. And I apologize, I don't have that case name. It just struck me that it's nice to see McGirt being applied elsewhere. And real quick, I see someone asked me a question. Says how would that apply? I think this is about subject matter jurisdiction. How would subject matter apply with the internet involved crimes? I want to for example.
That's for me to talk.
If somebody solicits somebody, say someone's on an Indian reservation, and they solicit a minor, say from the state of Michigan, both the state of Michigan and that the jurisdiction where the tribe lies, say let's say the Muskogee Creek Nation or the Cherokee Nation, either jurisdiction would have the ability to prosecute that crime, and it could be which or federal. And so if somebody is committing a crime from a reservation, but they use means of the internet, say is soliciting a minor, and they're soliciting somebody from Michigan, the state of Michigan or the U.S. Attorney's Office in Michigan or the U.S. Attorney's Office in Oklahoma could prosecute that crime, or the tribe if they have an applicable statute. Sometimes you can have jurisdiction in multiple locations when you have things such as contracts, internet, or some form of interstate commerce that's connecting one of the two jurisdictions. And arguably, because you have a tribal jurisdiction, a state jurisdiction, and a federal jurisdiction, all three of those jurisdictions could prosecute because they are separate sovereigns. You might be thinking in your head, wait a second, what about double jeopardy? Double jeopardy only applies if it's the same sovereign. Now, as a matter of practice, there's the Department of Justice has a policy called the Petite policy, where they don't double dip, they don't double prosecute. A lot of state constitutions provide for that, not all do, and a lot of tribes simply don't do it. Every now and then you will see where separate jurisdictions, separate sovereigns prosecute somebody for the same crime. And when I say separate sovereigns, that could be, the state of California versus the state of Oklahoma, or the state of California and the federal court, or the federal court and a tribal court. Since I have the background on it, I'll mention as well. The military has their own criminal code as well, the Uniform Code of Military Justice. The UCMJ, the Uniform Code of Military Justice, applies to service members, not family members, not spouses, only those in uniform, and has worldwide jurisdiction. So sometimes I have to remind people that a service member could commit a crime and could be prosecuted by the state, by a tribe, by a municipality, but usually since it's federal, the feds can't do both civilian prosecution and a court martial as well. So I want to throw that out there just to mention that. Before I go any further on that, I want to throw in a little bit about as a tribal court judge. Now, one of the courts I sit as a judge for is the Seminole Nation of Oklahoma. The Seminole tribe, as you may know, they came to Oklahoma from the Trail of Tears. There are still parts of the same tribe, but now split up that resides in Florida. And the Seminole Nation of Oklahoma is one of the tribes that McGirt appears to apply to. That being, and the application goes back to how the tribe obtained their reservation and how they allegedly ended that reservation. With the Muskogee Creek Nation, under the McGirt opinion, they received their reservation by a treaty with Congress. And what the United States Supreme Court has come back to say is that it has to be unequivocally clear that the reservation was disestablished. We can't talk about congressional intent. We can't talk about what we intended to happen or what we thought did happen. If Congress gives, which they did, Congress has to take away, which they did not. And that's really what McGirt came back down to. The Cherokee Nation, the Chickasaw Nation, the Choctaw Nation, and the Seminole Nation all have their own treaties with Congress. Those treaties gave them their reservation. And just like the Muskogee Creek Nation, there is nothing from Congress taking away those reservations. And that's really the whole analysis. If the tribe received their reservation by a treaty given by Congress, where was it disestablished? And I think that with a lot of the tribes around the country, they're going to be relooking at some of their boundaries on their land that they may have lost over time. How did they lose that land? And if it's not clear that they gave up that reservation, not that there was an intent, not that the state of wherever passed some act, it doesn't override what Congress did. And it's those treaties are probably the most powerful ones. Now, tribes can receive their reservations by different means. There are 39 tribes in Oklahoma. Not all of those tribes received their reservations by treaty. Some of them received them by administrative order, executive order, by some other means, and it was taken away by that means. What makes the Muskogee Creek Nation and the other 4 tribes different, and I'll go ahead and point this out, and some of you may have heard this phrase before, those 5 tribes historically were referred to as the 5 civilized tribes. Not the most PC term nowadays, but historically you'll hear someone talk about the 5 civilized tribes, which is pretty insulting to the other 34 tribes in Oklahoma. But they refer to the 5 civilized tribes. those tribes did have those treaties given by Congress and never taken away. And it's that simple. And the Seminole Nation of Oklahoma, being one of those 5 tribes that was reservation was given by treaty and apparently never taken away by Congress, their jurisdiction is intact. It's probably the smallest of the jurisdictions of the other 4 tribes. And as a tribal court judge, we are now seeing an influx of cases. The district attorney for Seminole County is just dismissing the cases outright. And I'm hearing stories that that the DA there is not giving it too much thought, and he's dismissing cases just because he thinks they look Indian. And somebody has to point out to him, no, they're Hispanic. Not everybody with dark skin is Indian, but the DA's, I think he's cleaning his docket out pretty fast. I don't know necessarily the judges in Seminole County agree with that tact on things, but we're now getting a lot of referrals from the state court over to the tribal court, which, again, we talked about the Major Crimes Act earlier. Your misdemeanors, when there's a misdemeanor offense and the defendant is Native American, only the tribal court has jurisdiction. If it's an assault, attempted murder, federal court has jurisdiction. But if it's a misdemeanor offense, the only jurisdiction that has the only court that has jurisdiction over that person is the tribal court. So the tribal court is seeing a huge influx of certain misdemeanors that we've never seen before, or not that regular. As a tribal court judge, we have a fairly busy criminal docket, but it's not that busy. We haven't had the need to work with bondsmen. We we as my experience with all the tribal courts I've worked in, we focus more on restorative justice. We jail is really the last resort. We work our best to protect victims. We work our best to find an answer, but we know that putting someone in jail just to warehouse them is never the answer. And that's one of the beautiful things about tribal courts, is that they look for the big picture. Now, ultimately, we understand that something has happened and the police had to go out. They had to arrest somebody, and we know that someone may be held a day, a weekend, a couple of days. But every tribal court judge that I've appeared in front of, practiced with, and in my own practice, leaving somebody in jail just because is not really an option. And the way we've kind of viewed it is, if they are a threat to the community and they need to be separated from society, then that's the right thing to do. But the far majority of cases, the far majority of individuals that are sitting in jail, it's because they can't afford a bond. That's not a reason to detain somebody. They've committed a crime. Well, is there a place for them to go other than jail? And so we look for solutions like that. And I understand that there has to be some punishment, and that's a part of punishment. But jail is not one of the things that a lot of the tribal courts are so quick to pull the trigger on. And that's one of the interesting things that we have right now, is we have a lot of arrests happening, a lot of things rolling over to the tribal court trying to implement its current practice, but it's a lot harder when your docket went from having maybe 10, 15, 20 people on the docket to now you have 40, 50, 60 on the docket. And if they stay in the county jail, that's just driving up court costs. And most tribes, at least in Oklahoma, and I speak from the Oklahoma perspective, don't have their own jail. They usually contract with the local county jail. And if they contract, the county turns around, charges the tribe. I had my experience in Oklahoma, they charge between $35 to $50 a day for an inmate. So it's not really, of course, as a judge, you're thinking about, well, the tribe's going to be paying for this. The tribe's going to be looking to court to recoup those costs from a defendant. Of course, you've heard about the endless cycle on debt you put on somebody when they come out of jail, or after a case. They pay a court cost, they pay restitution. Then in a lot of places they have what's called jail stay fees, or to pay for their costs of incarceration, and that can be this makes things much more expensive and a lot harder towards rehabilitation in making this individual a productive member of society. Question's been asked. Can I give a solution example where restorative justice when drugs are involved? I will say, and not every tribe is the same. And I will say, in my experience in working in different tribal courts, seeing the population that comes into court, and not just criminal matters. I'm talking juvenile matters, matters with guardianships, where there's a family that's troubled, with, if you call it child protective services or ICW case that we coming in. It's not uncommon in which I have a parent, a sibling, a defendant who's they're in a situation they're in because of drugs. And obviously in the big picture, drug addiction is probably the biggest issue. So where restorative justice comes in with drugs, usually that issue is we start working it from every angle and putting conditions that include, drug rehabilitation, drug counseling, drug classes. They do a drug assessment, alcohol and drug assessment from the very beginning. We also incorporate with some of the tribes some of their cultural. I'll call it the cultural remedies. One of the tribes they include sort of a sweat lodge session in which that's a part of their counseling, and it's if you were to step away from it to give it a more formal title, you would call it more of a counseling and meditation through a sweat lodge, which has been very productive. However, it's not. We've been very careful about as judges with all the tribes that we don't necessarily order something like that. If it's offered and if it's accepted, we will make it a condition, but we never order anything that might be, say, religious in nature, whether it's through a Native American religion or a local religion, that might infringe on someone's right on their choice to believe or not believe. But I've had several folks who, through the Native American church, and that's a part of their practice, they want to incorporate it in a part of their rehabilitation and restoration to healing from drug addiction. It's not, yes.
From the questions in the chat, you might want to clarify that when you're talking about criminal jurisdiction in tribal court, it's limited to tribal members. There was some question about Oliphant and whether that was going to be expanded after McGirt. So,
that's actually one of the good questions here. And I'm kind of pulling away, looking at a couple different screens here. With tribal courts only have jurisdiction over individuals, generally over individuals who are Native American, and in criminal matters, only members who are Native American. Now, I say that because I don't want to say tribal members, because the Muskogee Creek Nation Tribal Court, if I commit a crime, or another individual who's a member of another tribe commits a crime within the jurisdiction of the Muskogee Creek Nation, they are subject to the jurisdiction of that court. Even though they themselves are not Muskogee Creek Nation, they are a member of a federally recognized tribe. So so they are subject to that jurisdiction as well. Non-tribal members are not for criminal purposes. Now, in civil matters, which McGirt, there's an argument on how McGirt applies there. In civil matters, a tribal court can have jurisdiction over non-tribal members, non-natives. I have dealt with divorces. I've dealt with protective orders. I've dealt with lawsuits, contractual matters in which the people appearing before that court are non-native, and they either consent to the jurisdiction or they've contested the jurisdiction. They lost because they established enough contacts. I represent somebody in the Cheyenne Arapaho tribal court who, through a contract, they did business with the tribe, but they don't have the sufficient contacts with the tribe to be subjected to the tribal court jurisdiction, which you have to go through an analysis, which kind of goes back to, is there a sufficient contacts? And this is only in civil matters. Criminal matters, you have to be Native American within that jurisdiction to be subject to the criminal prosecution of that tribe. I guess, is Oliphant still stand? Yes, Oliphant still stands. However, it has to be looked at in the eyes of McGirt. I think it's going to be, obviously the analysis is always going to pop up, but Oliphant is still good law. McGirt just really addresses how a reservation was established and disestablished. And of course, when you find out that the jurisdiction has not been disestablished and a tribe's reservation expands, well, then you start looking at, well, were there crimes prosecuted by the state that occurred in this newfound land? If so, those prosecutions are no longer good. They have to be tossed out, whether they're ongoing today or they're from 20 or 30 years ago. Those convictions have to be tossed out and are no longer valid convictions. You also look at it from a civil aspect. If somebody is doing business within that jurisdiction, do they have to pay taxes to the state anymore? There is a Supreme Court case dealing with Native Americans who live on a reservation, whose income comes from within the reservation. They don't have to pay state income taxes. So, for example, somebody, and here's kind of the perfect example. That portion of Oklahoma, there's a high number of individuals who happen to be a member of a tribe. They work for a private corporation, say a small oil company in downtown Tulsa, and they live in Tulsa County. Well, they have an Indian card, thus they're Native American. Do they live on the reservation? Under McGirt, they live on the reservation. Does their income come from within the reservation? Well, even though it's a non-native company, technically they are sitting on the reservation themselves. The state of Oklahoma can no longer tax those individuals. And so, of course, I get a lot of questions about, well, what about back taxes? Well, that's a fight still to be had, and you're still on the side of right on that. So you've got a lot of individuals who are now saying, well, do I even pay state taxes anymore? And of course, now the tribes are looking at, well, we've never imposed an income tax before. Do we start doing that now? Because we are now going to be responsible for providing these services that we never had to before. We need to be able to operate our own government. Is the state of Oklahoma going to repair these roads anymore? Is the state of Oklahoma going to provide water and electricity? The tribe is going to have to come up with its own jail if they have to house somebody temporarily. They're going to have to fund all of these things. They're going to have to hire additional people to run more like a much larger tribe than they were before. And as the Supreme Court said, I think one of the questions that was asked is when McGirt was still pending, they said if McGirt holds that the reservation is still intact, there's going to be a lot of people who wake up the next morning and are going to be surprised to find out that they are actually living on a reservation now. The response to that, and I think it's one of the best responses ever, was, well, I think the tribal members of the Muskogee Creek Nation in 1864 would be very surprised to find all these people living on their reservation today. And it's just a matter of circumstances as to how it worked out. McGirt is a game changer. Now, here's the fear that affects not just the tribes in Oklahoma, the Muskogee Creek Nation, Seminole Nation, Cherokee Nation, Choctaw, and Chickasaw. Congress gives, but Congress can take away. If Congress comes up with a jurisdictional fix on this to return this land back to Oklahoma, and they do this, the danger is for those in Congress who don't understand, respect, appreciate, the sovereignty of a tribe, the history of the tribe. Will the changes that they make and that they're talking about making, how's it going to play out across the United States with every tribe? Congress is going, if Congress does anything, it's going to be stripping some sovereignty. And are they going to be stripping it of just the Muskogee Creek Nation and possibly the Cherokee, Choctaw, Chickasaw? Are they going to impose a quasi public law 280 state, something new on Oklahoma or only with those tribes? How is that going to play out for the rest of the tribes in the United States? And the biggest fear from within the tribes that we're all talking about is we're afraid that Congress is going to start stripping away some of the sovereignty that the tribes across the United States have fought so hard for. So that's one of the things that, that I guess I say that from your perspective is if you have a voice with your congressman, please keep an eye on it because that voice needs to be heard because we're all very concerned about what will happen if Congress reacts, and we feel that they're going to. We just don't know how or when. Um, we'll take a quick pause here to look at a couple questions that have popped up just now. Let's see. Can you discuss the legal process and status of review of the impact of McGirt on the 4 other tribes other than Muskogee Creek Nation? When do you anticipate these decisions will be made? Um, I think if I understand the question correctly, the status of the review and the impact of McGirt on the other 4 tribes. Those other 4 tribes being the Cherokee, Choctaw, Chickasaw, and Seminole nations. Uh, a lot of them have basically viewed that McGirt's going to apply. And in fact, I know that even the Attorney General's office for the Cherokee Nation has submitted amicus briefs to help out in state cases to establish the Cherokee Nation is still intact. I think they've all viewed it, just such as Muskogee Creek Nation, as we know that McGirt is going to apply. We know that some of the state court judges, and these have not been held up on appellate review yet, those are all still pending, will apply it. And a lot of these cases are going to start to become to our tribal courts, and we're not prepared to handle this influx. We're good for it. We can handle 10, we can handle 20, we can handle 40. We have people, we have judges, we have a lot of dedicated servants to the tribe, but can we take the influx of this many cases into our tribal court? And for some of them, remember, the Seminole Nation has one tribal court, but it encompasses several counties. So all these separate county DAs are going to dismiss all of their cases and send them to one court. So instead of hearing it in 5, 6, 11 different courthouses, they're all being sent to one courthouse itself, that being, the tribe of whatever, the Cherokee Nation or the Chickasaw Nation. So there's going to be a lot of adjustments that have to be made there. I think the tribes are taking it slow as far as how McGirt applies in other areas, taxation, land ownership, things of that nature. I've even heard someone give an analysis that, all land titles may actually be in question to a certain degree. If the land in question was never properly taken away from an Indian tribe, then, your house that you own, if you trace the title back, well, they never had the authority to sell that house sell that land in the first place to where your house was built. So is there a cloud on your title? And there's analysis on all of this. And of course, the tribes have no interest in taking away people's homes, have no interest in trying to, knock out entire, 50-story buildings in downtown Tulsa. That's not what they don't want to do that. They're not doing that. And they, of course, they just don't know what the answer is as to, okay, who owns it? Is it this private corporation that's a non-native tribe that technically now sits in the middle of a reservation? Do they have to give a lease back to them? How do they clean up this title? Let's see. Next question is, if a tribe is exercising special domestic violence criminal jurisdiction under VAWA, which is from 2013, the tribe has criminal jurisdiction over non-Indians for domestic violence. That's correct. Dating violence and violations of qualifying protective orders. I think what Ms. Librado was pointing out is there is some jurisdiction when it comes to basically crimes against women. VAWA created a special jurisdiction there in that limited circumstance in which a tribal court can exercise jurisdiction when there's a crime of violence that occurs within their jurisdiction within the reservation. And so, yeah, that should be pointed out. And thank you very much for pointing that out. I hadn't thought about the domestic violence aspect of it, but yes, there is a certain aspect in which a tribal court can exercise criminal jurisdiction over a non-native, but it has to be tied to this domestic violence prosecution. There's only certain crimes on that. And of course, the tribe has to make sure that they have legislation on it to prosecute those crimes. But it also leaves open for prosecution in the federal court as well, depending on the nature of the violence that we're talking about.
Judge, 2 minutes.
Okay, thank you. In fact, I was looking around for my clock to see where I stood at. McGirt, by the decision on McGirt, is one of the most exciting things that's happened in Indian country in a long time. A lot of us here, at least here in Oklahoma, who practice in this are it's fascinating to watch the education of those who know nothing about Indian law. And it's been an education process. And 6 months later, or longer, 8 months later, we're still having to educate state court judges on the basic rudimentary facts of Native American law. Uh, it is an exciting time. It's a fun time. If you're looking, if you are a writer or a law student, there's no better topic than McGirt, because there are a million different topics that spin off of it, whether it's criminal jurisdiction, state jurisdiction, taxation, or just how a government operates. It is by far the most exciting time to be in Indian country, and there's no other place that you'd want to practice as a lawyer than in Indian country. I will say this: I've always found that tribal courts operate so much better than what I see in the state courts. They look out more for the individual than the process. And I'm hoping that in this McGirt process, that the state courts will finally open their eyes and listen and learn from how they do business in Indian country and the tribal courts, because I think there's a lot of great lessons that the tribal courts and arguably the federal courts could learn from our tribal court jurisdictions. I know I've talked a lot. I know I've talked a little bit fast, so I apologize on that. Uh, Thank you very much for listening to what I've had to say. And, obviously, if you have questions, feel free to reach out to me. And I'm sure you can get my email address from, any of our sponsors here. Honored to be here. Thank you very much.